When the House of Representatives passes legislation, as it routinely does, there is no affirmative shall obligation on the part of the Senate for us to pass that legislation, nor is there any affirmative shall obligation for us to even consider that legislation. In fact, I believe in the last Congress, there were at least 300 or 400 bills that were passed by the House of Representatives that were never even taken up in the Senate, never given an opportunity for an up or down vote. This is the same kind of thing. Now, we can have a different discussion about politically or as a matter of policy, whether it's a wise thing to do what we as Republicans are doing. But that is a separate question. It is my strong belief that this is not a constitutional question because there is no affirmative constitutional obligation on the part of the Senate to act. The policy question and the political question must be separated from the constitutional question.
I think Senator Lee and I have a further conversation to have about separation of powers, the confirmation of a justice to the Supreme Court, U.S. v. Nixon, and whether or not his analogy, a good one, that the House and Senate send back hundreds of bills, and frankly, no harm, no foul. There is no shall, there is no constitutional mandate that we take up their bills or they take up our bills. But at what point does a refusal to engage or respond become so egregious to the functioning of the other branches that it raises the question that we're literally impeding the constitutional scheme? Can we claim a prerogative to understand advice and consent in a particular way that defeats the functioning of the judicial branch? I think that's worth discussing. I agree that there are political and policy concerns here, but for the long term, I worry deeply that the Senate continues to simply grind downwards in terms of its exercise of the confirmation power. Regardless of party, we seem to steadily head downwards in terms of our engagement, our purposefulness, and the positive productivity that we should be contributing towards constitutional deliberation in the course of confirmation hearings.